Tony DeWitt here, Missouri appellate attorney and a guy who answers questions on YouTube. And today we have a question from a viewer who wants to know what the burden of proof is. Well, it's more than just one burden, and I'll explain that in just a moment. The burden of proof can be broken down into two burdens: the burden of production and the burden of persuasion. Now, the burden of production means that the person who is responsible for satisfying the burden has to produce the evidence. Now, that can be in the form of testimony. I saw Joe hit Bob. Or it can be in the form of video evidence. Here's a video of Joe hitting Bob. Or it can be in the form of documents. Here is the police report where the police investigated Joe hitting Bob. All of those things are evidence, and that is the requirement of the person who has the burden of proof. They have to produce the evidence. But the far more important part of the burden of proof is the burden of persuasion. Merely producing documents and photographs and video is not always enough to satisfy the burden of persuading the jurors. The jurors have to be persuaded in order to give you a verdict, whether it's in the civil court or whether it's in the criminal court. They have to be persuaded. So the burden of proof really consists of the burden of production and the burden of persuasion. Now, who has the burden of proof? Well, in a civil case, it is normally the plaintiff. For example, in an assault case, here is the burden of proof: that the act was intended to cause apprehension of harmful or offensive contact, and that the act indeed caused apprehension in the victim that harmful or offensive contact would occur. Now, assault can be drawing back your fist. It can be any number of things. In many instances, pointing a firearm or bringing out a knife and pointing it at someone can be considered assault. So the plaintiff in a civil case for assault would have to prove those two elements because it's his burden to satisfy in order to get a recovery. But it's not always the plaintiff's burden. Sometimes there are affirmative defenses in cases. An affirmative defense is a defense that the defendant can prove that eliminates his liability or his guilt. One of the most fundamental affirmative defenses is the statute of limitations. Every state has a statute that determines how long a person has to bring a lawsuit for a particular tort or contract action. If you file it outside of that statute of limitations, unless you're governed by an exception, that's an affirmative defense to getting a recovery under the civil law. You plead the affirmative defense of statute of limitations, it's out of the statute of limitations, and the defendant would win in that case. Okay, so who has the burden of proof in the case of a criminal case? Well, that's always going to be the state. Again, unless there is an affirmative defense. In some states, the defense of self-defense is considered to be an affirmative defense that the defendant has to prove either by a preponderance of the evidence or some other standard. Usually it's by the preponderance of the evidence. Some states, like Florida and Ohio, have eliminated the defendant's burden of proof. Instead, in Florida, for example, they require the state to prove that there was not self-defense, that the elements of self-defense do not apply. It not only puts the burden of proof on the state to prove the elements of the crime, it also puts the burden of proof on them to disprove the elements of any affirmative defense. That seems to me to be a bit more fair when we're talking about affirmative defenses in cases of self-defense. There are lots of other affirmative defenses. There are defenses, for example, accord and satisfaction, which essentially means you've paid off a debt. Arbitration, this is governed by an arbitration agreement and it's not a remedy that can be sought in court. All kinds of affirmative defenses can be pleaded in both state criminal actions as well as civil actions, and the recovery will depend on that. When an affirmative defense is pleaded, in almost every case, the burden of proof remains with the person who's pleading that defense. So, what is the standard of proof? In other words, to what degree does a plaintiff have to demonstrate that he has satisfied the burden of proof? One of the things that lawyers do in the process of voir dire is they talk a lot about the standard of proof. In most civil cases, with but a few exceptions, the standard is a preponderance of the evidence, which means that all the plaintiff has to do is tilt the scales slightly in his favor. It just has to be more likely than not likely. So we oftentimes refer to that as a 51% standard. If we get 51% of the evidence going our way, the scale tilts and we win. But in most cases, the standard will remain at a preponderance of the evidence, and that is indeed what the jury instructions are going to detail. That will be the standard that the jury instructions recite to the jury and guide their deliberations. In some cases, particularly where there is a situation involving punitive damages, the standard of proof is clear and convincing evidence. So, for example, if we have to prove reckless disregard of a person's rights in order to get punitive damages, the evidence showing that reckless disregard has to be clear and it has to be convincing. And again, that's what the jury instruction will demonstrate. Now, of course, in a criminal case, it is beyond a reasonable doubt. I've already done a video here on the standard of proof for beyond a reasonable doubt. I'll link it up above. And obviously that was probably more in depth than what I could do here. Suffice it to say that beyond a reasonable doubt is not beyond all doubt, because it's always easy to conjure up some doubt. It's beyond a reasonable doubt. And that is a standard that most jurors are more than capable of applying. So there you have it. That is the standard of proof and the burden of proof in a nutshell. I hope that you found this helpful or useful or informative. If you have, I would appreciate it if you'd click the like button down below. Clicking the like button makes you feel good and it costs you absolutely nothing. In addition, if you haven't already, please subscribe to our channel so that you don't miss any more of these videos. And that's easy to do. You push the little subscribe word on the YouTube channel and select the notification bell, and you'll be notified every time we release a video on this channel. Thank you so much for watching and have a terrific day.